Yes, sir.
I am John Baronic, and I'm representing the appellant, who are Mr. and Mrs. Carlson. And this is a case which concerns the Carlsons' attempt to purchase a condominium. The deal fell through, and the Carlsons sued to get their deposit back. And the trial court entered a summary judgment holding that the developer was entitled to keep the $880,000 deposit. That's what the case is about, the $880,000 deposit. As it turned out, the developer promptly sold the condominium for $4.1 million, and that's simply an uncontested fact.
But you're not contesting the liquidated damages?
No, no.
Okay.
The trial court, both parties moved for summary judgment, actually. And the trial court granted the developer's motion and denied the purchaser's motion. Court order is quoted verbatim in my brief at pages 14 through 16. And one of the more important parts of that order is paragraph 5 that talks about the purchase agreement and the prospectus as both being the basis for the summary judgment. In fact, the purchase agreement simply does not mention the beach club in any way whatsoever. And that was simply a mistake that opposing counsel caused when he drafted the order. It constituted an error. The fact is that, of course, this is a summary judgment. There cannot be any issues.
But the contract does provide in paragraph F that the unit and the condominium will be constructed in substantial accordance, quote, in developer's opinion, with the plans and specifications kept in developer's constructions office, as such plans and specifications are amended from time to time. So amendments were contemplated.
Amendments were contemplated.
And the beach club was mentioned in the initial prospectus, which your clients didn't get. But they ultimately got the amended prospectus, which wasn't actually amended, which wasn't labeled amended, but it in fact was the only one they ever received up till that point. And that started their clock ticking, the 15-day clock to rescind for any reason. I mean, is that correct?
Correct.
And did they exercise their right of rescission?
And they did
within the 15 days.
Within the 15 days of that last piece of paper.
Well, don't try to twist my words now. The prospectus they were given that you claim was not labeled amended, which is corroborated by the record, it was not amended. They didn't exercise their right to rescind within the 15 days under the 503 version of 718 for any reason whatsoever. That 15 days lapsed, and they signed a receipt saying that they received all the documents to that point.
Well, yes.
Then we can get to the issue. Your issue was, for example, that they still had the 15-day clock is open to this day.
Yes.
Okay.
Yes.
Now we're on the same page.
In other words, and my position is quite simple, that they didn't get the original prospectus. They were entitled to receive the original prospectus from this developer. This developer did not give them the original.
The problem I'm having is I think the judge found something in the judgment that basically said that didn't make a difference. It was kind of moot because that's not the one that applied, and they're not debating that the 15-day clock didn't start or stop on that original prospectus, but they're saying it started and stopped on the amended prospectus.
Well, Judge, no, I don't think that's our position.
Okay.
Our position.
I mean, that's their position.
Yeah. Okay.
Sorry.
Obviously. No.
Yeah. No, you don't agree with that.
The prospectus. I mean, what it boils down to in the very beginning is they didn't receive the original prospectus. Both parties have argued this at length in the briefs as to whether or not we were entitled to the original prospectus. And we think that the law is just absolutely clear that we were entitled to that original prospectus, and they didn't give it to us.
Tell me, what clear law is it that leads you to the conclusion that an abandoned original prospectus that the developer basically decided we're not going to go forward with this development this way, we're going to change it and do something different? What law is it, what statute, what case that leads you to believe that this abandoned original prospectus, if you will, was still required to be given over as part of the documents?
Well, our argument is really very simple. It is, well, why not? Why are we not entitled to receive the original prospectus? I mean, there's no question under the statutes we were entitled to the original prospectus. We didn't get it.
And that's what I'm asking. You're saying there's no question under the statute. What language in the statute leads you to that conclusion that you were entitled, without any caveat, without any further preconditions, to that original prospectus that the developer did not provide but wasn't going to proceed forward?
Well, my co-counsel has handed me 718.502, which is the statute that would have required them to furnish us with the original prospectus.
Well, your client did pay money, though, after getting the amended prospectus.
Yeah. Oh, absolutely.
So don't we have like a novation, a whole new deal going forward?
Judge, we didn't know that they hadn't given us the original prospectus immediately. We only found that out later.
But I guess the question is, what difference does that make if it was changed? And the Beach Club issue is what we're here over, and then your argument switches to material and adverse.
Yes, sir. Well, if we can simply go to what they gave us in the beginning. In other words, not only did they not give us the original prospectus, they furnished all kinds of documents showing that the Beach Club was going to be built. Yeah, and we have attached those as exhibits.
You're talking about the diagrams?
Yes, sir.
And don't they have in the lower left-hand corner a proviso that these could be amended? We may not build it exactly the way you're looking at it?
Certainly they do. But I mean, and exhibits C, D, and E attached to our motion for summary judgment show this very large building, and next to it, on the ground level, a two-story beach club.
Well, let's say, for the sake of argument, that that's a material change, right?
Right.
I mean, it seems like a big change to me.
The fact that they never built it is a big change.
But they substituted other things, the restaurant and another
They
pool,
contend,
Then they called an expert, this Cindy Carroll individual, to testify, well, it's kind of a wash, or maybe they're a little bit better off, but it's not adverse, looking at the whole of what was done. And then you attach the deposition of your client to say, well, to me, it's a big difference. But the standard is an objective standard to a reasonable person, and then the Cindy Carroll is the only testimony we have to say it's not adverse. And you proffered nothing in opposition to the summary judgment or trial counsel below.
Well, however, Judge, I mean, we got drawings, pictures showing a beach club. We didn't get a beach club. We got, instead, a restaurant seating 250 people on the second floor of the tower building. That is what they built in place of the beach club. Now, maybe the restaurant cost them more money to build. That's not our fault. We were entitled to a beach club.
Was that restaurant disclosed as part of the plans or the amended prospectus?
It was disclosed eventually.
And did they rescind after that disclosure within 15 days?
No. They never gave us that until much later in the case. I mean, this case went on for 5 years, and as I said, we didn't even.
I'm talking about as far as presumably there's something in building plans, or there's something in a prospectus talking about building this second floor out as a restaurant.
I'm sure there is, but that has never really been an issue in this case.
Okay.
And we invite the court to please just look at the first 3 pages attached to our motion for summary judgment, which shows this building, a 2-story beach club building, which we didn't get.
Mr. Bragg, I guess I'd like to go back to the very basic, if I may. I'm still troubled with your position that by virtue of the fact that you did not receive the original prospectus, and I think you're relying on 718.503, that basically any further chance of a developer's right to cure to give you the prospectus that would be applying to this, I'm concerned because I'm looking at the statute. The statute basically, I like to always think that the laws are common sense. What the statute basically, it requires a developer to disclose to your clients before any sale. That way your client could be well informed of what exactly your client is getting into. And I guess what I'm concerned with is that your clients were privy to other things that they were provided, and it's not like they paid the initial $100,000 and then they stopped paying. They continuously paid other down payment, other down payment, other down payment, when they received information that things are changing, that the beach club may not be built, that other things are being. That's where I'm struggling with, Mr. Bragg. So help me out. Why am I wrong?
Well,
why am I going the wrong path?
The reason why is because of the developer's position in this appeal. The developer contends in this appeal that they did not furnish this to the Carlsons, that they did not give them this prospectus because they were considering making changes.
Well, no one, apparently none of the purchasers got the initial prospectus because it was being amended during that 2-month window where they finally came out with the amendments and provided it to your clients.
I'm sorry, Judge, I didn't.
No initial purchasers got that initial
No,
prospectus.
that's right.
Because it was allegedly being amended. There's no countervailing evidence to say there was any kind of trickery
Right.
associated
In other words,
with that.
they
eventually got the amended prospectus.
Right.
The one that we're here on today.
And of course, we don't think we're here on the amended prospectus. I mean, we think we're here on.
Well, if it wasn't amended, we wouldn't be here. Right. Okay.
True. And you see, I mean, we're not suing to get the condominium. We're not trying to hold their feet to the fire and have them turn over the condominium to us. We are suing just to get our deposit back. In other words, that's all this lawsuit is about. The 800, of course, this is a significant condominium, and the deposit was $880,000. And my co-counsel keeps reminding me to please tell them to look at the Klinger case. And,
right.
And we have cited Klinger in our brief and argued it, and it is a case which is directly on point. It's a case involving a condominium, and instead of refusing to build the beach club, the developer in that case chose not to build a jogging path. And the customer said, I want my money back, and the District Court of Appeal initially ruled in favor of the customer, and then on rehearing totally changed the opinion and said, no, if you make this kind of change, the customer, the buyer, is entitled to get all of his money back.
But in Klinger, you also had some additional facts. There was a 4-phase development allegedly to consist of townhouses, and after they did phases 1 and 2, they changed phases 3 and 4. Instead of townhouses, much smaller condos. Totally different scenario
There were
than what we have.
There were differences.
And they also mixed up the 718-503 and the 506 analysis. It's hard to read Klinger and figure out, is it a 503 or is it a 508 reason for reversal? They do the 506 analysis for material adverse, but then they say this is under 503. So I'm not sure that's the best precedent that you have, that we absolutely must follow, because on their side is the Marstalla case, which seems more directly on point in terms of a clear-cut analysis that we need to engage in on this material and adverse situation.
Well, Klinger is not as good as I would like it to be, of course, but I think it's directly on point, and they did rule for the customer, the purchaser, and that decision sort of goes on because they wrote a decision in the beginning, and then on rehearing they totally changed their mind and went in the other direction. But we still say it is, without question, the closest case in Florida to this situation. And under Klinger, we're entitled to have our deposit returned.
All right.
Thank you.
Thank you so much. I'm giving you 4 minutes rebuttal.
Thank you.
May it please the court, Jeff Fridkin here for VI Limited. Let me just spend a moment with Klinger and walk into where the distinguishment is between our circumstance and that case. Judge Villani picked up on it with respect to phases 3 and 4 being much smaller condominiums, but the other really important piece of Klinger that isn't present here is that the condominium owners in phase 1 and phase 2 were specifically granted a right in the jogging path and the Vita path if 3 and 4 were built. 3 and 4 got built, but they didn't build the jogging path, and there was a right apparently, although interestingly the language itself is never really lifted and published in the opinion, but the court's description was that the developer retained a right to change or not build it. But it apparently, because we don't get the actual quoted information, but apparently there was a right set forth that if they did go forward, then the jogging path and the Vita path inured to the benefit of units 1 and 2.
Well, counsel at the hearing below, I'm not sure if it was you, but whoever represented your client below stated at the hearing on the motion to dismiss that if 6 Limited actually built the beach club, then a Klinger decision would control.
That wasn't me. I'm aware of that argument having been raised in the context of a motion to dismiss about 2.5 years before any of the issues from a factual standpoint were built. I don't consider that an admission that binds the.
I mean, because was the beach club actually built, but not but on the second floor? I mean, are we arguing that that's a beach club, not a restaurant, or what's going on?
Yeah, if I might try to bring some clarity to this. The answer to the question of what is there is really found in, I believe it's section 4 of the prospectus that talks about alternative planned phase 5. And I'm going to get to what's in there right now. The bottom line of what's in there is there's a club in phases 2, 3, and 4, which have been reshuffled, if you will, in terms of where they are on this property. But it is essentially a place where if you wanted to have a drink or have some food, you could do that. The distinguishing piece between what this condominium offered and what was dealt with in Klinger has to do with the fact that never was there any right or interest of any kind on the part of a condominium owner in and to the beach club, and that is made very express in paragraph 4. It says, membership or the right to apply for membership in the beach club is not a right appurtenant to condominium unit ownership, purchaser's execution of a purchaser agreement, or purchaser's acquisition of title to a unit in the condominium does not provide purchaser any right or interest whatsoever in or to the beach club, or in or to subsequent phases 2, 3, or 4. Developer is not obligated to develop the beach club at all. So,
As I understand appellant's arguments, why they're saying that Klinger should apply, as I review the record below, they're taking Klinger, what Klinger basically said, that there was a substantial deviation from the original development plans because of the jog path. They're taking an issue here, as I understand their argument, this is summary judgment, the fact of beach club, where they're showing renderings or showing drawings that the beach club would be up, question of fact as to they were misled, or maybe they thought that that beach club was going to be built, and instead, here's this on one floor restaurant that's open to the public, not even exclusive to that. As I understand, that's the issue that they're concerned with.
and the trial judge below addressed that very argument in the provision, I believe it's paragraph 5. And what the trial judge ruled was that plaintiffs' alleged reliance on misrepresentations regarding the availability of a beach club or golf course, they've let that one go on the appeal, but they talked about it below, in connection with the purchase of a unit is expressly contradicted by the written provisions of the purchase agreement and the prospectus. Now we're getting into the TRW case.
Okay, now, but so here's where I think I'm not making their argument. As I understand theirs, it's summary judgment.
And
so can that be reconciled at summary judgment? Or does it need to
absolutely,
go forward?
and I'm sorry, I said TRW, it's TRG
Yes,
Nighthawk.
no, I understood.
TRG Nighthawk basically said, and it's picked up on Hillcrest and a lot of other cases out of this court and other courts, that where the written document contradicts the basis of the alleged misrepresentation, the document controls. There can't be reasonable reliance. There's no fact issue for the underlying court to consider when the allegation is made that, hey, I was promised a beach club, I saw it on the color glossy, and clearly there were reproductions that showed this beach club being out there. But the agreement that was signed that these folks entered into flat told them that we may get the right to build a beach club, but if we do, that's our property. It doesn't belong to you. When you buy a condominium at Mariah Bay, you do not have any appurtenant interest of any kind or nature in the beach club. You don't have a right to be a member. You don't have a right to participate in it at all. And that's what the writing tells them at the time they buy. Now,
And the contract has a no representations clause in it.
Absolutely. No oral representations. And in fact, the contract draws the representations solely to the prospectus and the agreement itself.
And the diagram has a disclaimer in the lower left-hand corner.
Yes, sir. And so when the trial judge was hearing these motions over a 2-hour period of time, we were a week away from starting a non-jury trial. There wasn't any suggestion, and there really is no suggestion here, even in the briefing, that there were genuine issues of any material fact. Clearly, it is the Carlsons' position that they expected a beach club and that their expectations were dashed because we didn't build one. But the facts remain that the agreement that they signed on to, and you correctly noted that after 15 days of having the prospectus, they plunked down another $340,000. And a year later, when we commenced construction, they plunked down another $440,000. So in that interim, in that 15-day period, when they read the prospectus, they were clearly, unambiguously advised that they had no right.
The court had all the proof, all the documents, all the law, all the relevant testimony, made a decision.
Yes,
We
sir.
would reverse and send it back. the same thing would likely occur. There's nothing that wasn't said. Nobody argued to continue the hearing. Nobody argued to get more evidence. Everything was submitted, and the court made a decision after weighing everything and applying the law to the undisputed facts.
That is correct. And if I might add, there was an affidavit of a lawyer, Cheryl Hastings, with our law firm, that explained what got changed. And she describes the fact that it was not only the prospectus that was amended, and I want to get to the reasons why it's a bad rule to say that prior documents which are no longer functional should ever be provided, because they become a source of confusion. They could become a source of all sorts of allegations of misleading.
Well, on that point, though, I mean, 718-503 does say the documents to be delivered to the prospective buyer are the prospectus.
Yes.
Or disclosure statement with all exhibits. Now,
Yes.
Now, my understanding, and correct me if I'm wrong, is that by filing and getting approval of that original prospectus, that then authorized your client to start putting together these nice sales materials, to start entering into binding contracts.
I would suggest that that when you say binding contracts.
Excuse me, the contracts that you're not worried about having rescission hanging over your head, or
I believe that they can commence sales. What actually
based on the filing and the approval of the original prospectus.
I believe that's correct.
Okay.
I believe that's correct.
So I guess to bring it full circle, to echo Mr. Berenik's point, why not provide the original prospectus?
Because in this particular instance, as set forth in Ms. Hastings' affidavit, which is in the record here, we had changes to the prospectus, the declaration of condominium, the survey, the plot, the floor plans, the budget notes, the Q&A sheet, question and answer sheet, which is part of the condominium materials just as much as the prospectus is, the association budget, and frankly, the magnitude of those changes were sufficient enough that the developer made a conscious decision to provide them to nobody, because
But the developer agrees that prospectus wasn't provided.
it was not provided.
The developer doesn't dispute that the remedy would have been the 15-day period would get extended until the proper prospectus is provided. Whichever perspective is provided is the operative perspective. The fact that the original wasn't provided isn't going to change the fact that the 15-day right of rescission for any reason is tacked on to the end of the period of when the prospectus is provided. Under their scenario, you didn't provide the original, the 15-day window never started, even though it started. It would be anomalous to say it started on the amended prospectus but didn't start on the original prospectus. So, you know, to me, there's a little bit of confusion that you may want to address. Why go with 2 versus 1?
And I think the correct answer to that is that the whole purpose of the statute is to create clarity to the purchaser of what it is they're buying.
And the lack of high pressure, go speak to a lawyer, and if there's something you don't like, you get to get out of the contract for any reason.
That's correct, for any reason whatsoever. From the developer's perspective, to have provided a huge bundle of this information in a completely red line changed, condition, you would create more confusion than doing what we did, which was we supplied precisely and exactly what it is that the purchasers were buying. We gave them a prospectus which explained what it is they were getting. And that, we believe, is what is called for under the statute. I think it's quite clear that that was the purpose of the statute. And if you look at the purchase agreement, you'll see that it anticipated that the prospectus was not being delivered at the time the agreement was entered into. And of course, at that moment, it's a completely voidable document. $100,000 was put down in February of 2006 to reserve a unit. The express terms of the purchase agreement go on to say that when the condominium documents, which include but go beyond the prospectus, are delivered, and after the 15-day rescission period, the next payment of $340,000 was due. So it's taken me a long time to try and get to where I think the correct answer to your question is, Judge Valenti, but it was after that 15-day period when the correct prospectus explained the product, the bundle of rights, that the buyer either elected to rescind or plunk down the money, and in this instance, the Carlsons plunked down the money.
Also, the amended prospectus, there's no dispute that they were given 15 days to rescind for any reason, and then they argue in the alternative there was material and
Adverse changes.
and adverse changes.
Yes.
So you were defending on both positions. You weren't trying to deprive them of the 15-day open-ended position.
In no way, shape, or form.
And there was no countervailing evidence that it was not adverse.
That's correct. The only changes that were brought
Now,
out
it may
below.
have been adverse subjectively, but that's not the test. It's
Precisely.
an objective test.
They faintly, is I think the best word I can use, argue about materiality and adverse in their brief, but the reality, and you already noticed it, we had an MAI appraiser, Cindy Carroll, do an assessment of what a reasonable buyer would think in the circumstances with respect to the beach club, the lap pool, and the fitness center. And in each instance, it was this appraiser's opinion that the reasonable buyer would be unmoved. It was not in any way, shape, material to the buyer's decision. The lap pool changed by 100 and some odd square feet, which went from the pool to the deck area and was, you know, by the developer's affidavit value additive, by Ms. Carroll's affidavit, it was revenue neutral. It wouldn't make any difference.
There's no further details on what is meant by a beach club anyway.
That's correct.
We don't know what the menu is, we don't know this, we don't know that. The same thing about we're substituting a restaurant and a lap club and access to another swimming pool.
If you look at the plot plans that are attached to the prospectus that are in the record, you'll see the areas where beach club, where the lands are not being submitted to condominium. Phases 2 and 3 are actually on the second floor of the tower, and they exist now. They have been moved in the last, the July 2009. There was a portion of what is today the fitness center that was at one point anticipated to be part of the beach club. That part has actually gone to the benefit of the condominium owners. The ground where this freestanding building was considered, and it was considered, as they have pointed out, and we don't run away from it, we made an application to the local building authorities to build it. For reasons that aren't in the record, ultimately the freestanding building didn't get built. But the land where that freestanding building is actually part of the functioning beach club. If you had membership, you would be able to be swimming in the private pool that is there and have a nice cocktail or other libation or whatever, iced tea, as you enjoyed the sound of the Gulf of Mexico pouring in. So I think that where these issues of material and adverse are concerned, the only record evidence, the only thing before the trial court, but it was competent, was that no reasonable buyer would find any of this to be material or adverse. On the issue of misrepresentation, the document itself controls, and it would activate the rule in TRG. And with respect to the issue of the October 2005, providing that information would create more confusion and create more risk of misleading people than what happened here when they were given the accurate description of what it was they were buying, and they had 15 days to figure out whether they still wanted to go forward or not.
All right, thank you.
Thank you so much.
Mr. Baranik, I think you asked for 5 minutes rebuttal, which I'll be happy to give you.
The contract was entered into in February of 2006, and the March 2006 documents were amended documents. They never told us, when they first sent us these amended documents, they didn't even tell us they were amended documents. This is a developer that is
But
supposed...
your client testified he didn't actually read them.
That's true. He read them but didn't understand them, he said.
Okay.
But they didn't tell us what they were sending us. Why not tell us this is an amended document? Because if they had said that, they would have had to follow up and say, it's an amended document, but we didn't give you the first document we were supposed to have given you, which was the original prospectus. They would have had to tell us that, but they didn't. They were keeping it secret. And the briefs before this court by this developer make it clear that they were intentionally not providing the prospectus, because they didn't want us to have them. That's what they say in their brief. And they say, we intentionally chose not to give them the prospectus because we were thinking about making changes. And I have argued in my reply brief that there is absolutely no Florida law whatsoever that excuses a developer from doing his legal duty of providing documents to purchasers because he's thinking about making changes.
How does a developer cure that problem? When they ultimately make the changes and it's codified in the amended prospectus, even though it doesn't say amended, but they're giving that prospectus to the purchaser for the first time. So from the purchaser's point of view, that's the prospectus that's operative. Why would they not be able to say, I gave you the prospectus, although not one that doesn't apply, but I gave you the one that does apply, and I'm not disputing that you have 15 days from when I gave it to you versus 15 days from when you signed the contract, but 15 days from when you got the prospectus. They're not trying to get any additional remedies cut off that the buyer still has under Chapter 718.
Well, Judge, this simply, that would be a whole new page in Florida condominium law.
There isn't any case law that strictly interprets the Chapter 718 to throw in, plus any previous documents that don't apply have to also be furnished.
Well, except, Judge, we have given you 4 cases, one of which is the Klinger, where...
They deal with material and adverse, also in different factual...
Well, yes, I'm not saying that they're precisely the same, but they're very close. They're certainly a lot closer than anything they've got. And they pretend that Klinger doesn't exist. They don't cite it and don't cite the statute that is being construed in Klinger. They simply refuse to mention it. And at this point, this case presented issues of fact that barred summary judgment.
You're down to about a minute, just so you know.
I will finish in a minute.
Okay.
There were numerous conflicts in this case. They didn't provide the original prospectus and didn't tell us that they didn't provide it. But they did say in the prospectus they finally gave us that an affiliate would build the beach club. that's their word, an affiliate of theirs would build the beach club. They then filed a county application to build the beach club. They circulated the renderings attached to our motion for summary judgment, telling us that they were going to build the beach club. And then Mr. Koras, who is the company's vice president, filed his own affidavit where he says several different times that they have built the beach club. That's what he says. He says it is a private beach club on the beach. And that is simply false. That's not true. And that, among those four things, barred summary judgment in this case.
All right, that'll be the last word. Well argued, well presented. Thank you for coming. We'll be in recess.